a motive, a beating, a confession. Ladies and gentlemen, beyond a reasonable doubt, the state has proven that on March 24th, 2025, Gerhardt Konig tried to kill his wife, Arielle. The state has proven beyond a reasonable doubt that Gerhardt Konig committed the offense of attempted murder in the second degree. There are two elements, as Judge read to you a couple minutes ago. Element number one, on or about March 24, 2025, that if in the city and county of Honolulu, the defendant intentionally engaged in conduct. Element number two, we'll get back to in a moment, but the conduct, starting with element one, what is the conduct? What did defendant do? First, he tried to push her. That's the first conduct the defendant did. The second, the syringe. He tried to inject her with an unknown substance. And third, the beating with the rock. That is the conduct that defendant engaged in intentionally. That is the conduct that we are here to talk about for the last several weeks and for today. The second element, that conduct, under the circumstances under which defendant believed them to be, was a substantial step in a course of conduct intended or known to be practically certain by the defendant to cause the death of Arielle Konig. So element number one, simple, it's conduct. Element number two defines what that conduct is, what it's meant to do. And the conduct in this case was meant to kill. The intent behind each one, plan A, the push, the intent was to kill. When plan A didn't work, the defendant moved on to plan B. Plan B, inject her with the syringe, knock her out, push her off the cliff. The intent behind plan B was to kill. Plan C, when the first two plans didn't work, beat her with the rock, knock her out, drag her over, or just simply kill her outright. The intent behind every single plan was to kill Arielle. Every plan, every backup plan ends in Arielle's death. A substantial step starts with the plan. The plan's in yellow because it's not a substantial step yet, it's just a plan. Next, the hike. Again, it's in yellow because he hasn't taken that last step. That last step to show he's committed to carrying out that plan, that shows he's committed to killing Arielle. The first time you get that is with the push. When the defendant takes his hands, tells Arielle, I'm sick of this shit, and tries to push her back off the cliff. That is the first substantial step the defendant took. That didn't work. Arielle went to the ground. Arielle protected herself. The defendant took the next substantial step. He took that syringe out and he tried to inject her. But Arielle fought back. Arielle fought back, fighting for her life, knocks the syringe away, and then the defendant moves on to plan C, his third substantial step, where he takes that rock, Exhibit 2, this rock right here, the same rock that you've all held, he takes this rock and he beats her with it again and again and again and again. Those three steps are the substantial steps the defendant took to carry out his plan to kill Arielle Konig. Before we get any further, what is not a defense? The result of the defendant's conduct. The severity of Arielle's injuries, you'll hear many times trying to minimize them. That is not a defense. The law treats somebody the same, whether they're successful or not. The law treats you the same no matter how good you are at executing that plan, no matter how good you are at actually succeeding in killing somebody, the law treats you the same. As an example, somebody who tries to shoot somebody, who points a gun and tries to end a life, but misses, they've committed attempted murder the same way the defendant committed, in a similar way, in a similar idea as the way defendant did it in this case. You cannot look only at the results to determine intent. You have to look at everything together. And when you look at everything, it shows one clear answer beyond a reasonable doubt, and that's that the defendant intended to kill her. Let's review how we got there. First, we have Arielle's testimony, and she testified in 3 different areas. First, Arielle told you what happened on the Palipuka Trail on March 24th, 2025. She told you what happened when she went up the trail. She told you how she was afraid, how she was nervous about the heights. She told you how the defendant reacted. She told you what happened when she met up with the defendant later, that he pushed her, that she went to the ground, that he took the syringe, that she fought back, and then ultimately he took that rock, this same rock, and hit her in the head again and again. Then Arielle told you what happened leading up to that day. She told you about their marital issues. She told you about her messages with Jeffrey Miller. She told you all of that. Embarrassing as it may be, she put it all out there. And then Arielle told you about her treatment, her medical treatment, her recovery. She showed you the scars that she carries to this day. She showed you the scars on her head where she will never grow hair again. And everything that Arielle said is corroborated. These are the credibility factors. These are listed in your instructions that you should be considering for every witness who testified. And I'm not going to go through all of them right now, but there's a couple that are relevant for Arielle here. First, appearance, demeanor, intelligence, candor, frankness. Arielle testified in a straightforward, coherent manner. She testified clearly. There were no histrionics, barely any tears. It was straightforward. This happened, then this happened, then this happened. It was not over-dramatized. It was not over-exaggerated. It was straightforward and simple and coherent. She was open to cross-examination. When the answer was yes, she said, yes, sir. When the answer was no, she said, no, sir. And when she didn't know, she said she didn't know. But the last factor is the most important here. The extent to which Arielle's testimony is supported by other evidence. What this means, simply, is corroboration. What level of corroboration is there? There is a lot. Arielle is corroborated by the physical evidence, the scene and location, the rock, the blood evidence, the injuries, the medical supplies. Arielle is corroborated by the digital forensics. What was going on the defendant's computer corroborates what Arielle said. Arielle is corroborated by the other witnesses, by their sworn testimony, by Emile Konig. Arielle is corroborated by Amanda Morris. She's corroborated by Sarah Buxbaum. She's corroborated by HPD. And in the most important ways, she's even corroborated by what the defendant told Emile. You've seen the photos of the scene. Arielle's testimony is corroborated. There's the cliff. It's right there. There's the blood pool in the bush where the defendant was on top of her, where the defendant was hitting her. The physical evidence of the scene, the blood, the crushed plants, the location of this, so close to the cliff edge, all corroborates Arielle. The physical evidence, the rock, corroborates Arielle. You've held the rock. You've seen it. You know how much it weighs. You know how sharp it can be on the sides. You've seen the photos of Arielle's blood and Arielle's hair on that rock. The rock corroborates what Arielle said. The DNA evidence. The DNA evidence shows 2 things very clearly. 1, every single sample that was positive for human blood had a likelihood ratio of over 1 trillion for Arielle Konig. Every single one. The blood on the rock, the blood on the samples from the trail, the blood all over defendant's shirt and shorts. Every single one had a likelihood ratio of over 1 trillion for Arielle. Reason and common sense tells you all of that blood is Arielle Konig's, not the defendant's. Second, Arielle Konig's DNA was on both sides of the rock. And think back. Think back to how Arielle demonstrated what she did. She held up her hand. She held up her hand trying to block the defendant. She suffered defensive injuries from it on her fingers, on her thumb, and that's how her DNA is on that rock. Because she touched it. Her touch DNA is on the rock because she touched that rock to try and stop the defendant. The search warrant of defendant's work bag on Maui corroborates Arielle's statement. It shows clearly, conclusively, that defendant had actual possession. Not as some sort of theoretical, oh, he's a doctor, he can get this stuff. No, he had actual possession of syringes, he had actual possession of vials, he had actual possession of drugs that can kill. This isn't some, he could have gotten them, he had them. This corroborates Arielle's testimony. And more importantly, these drugs weren't stored in a controlled environment. They were stored in his home, where he had access. He could take them, didn't have to log them or anything, just remove them from his home and do whatever he wanted with them. This corroborates Arielle as well. Lastly, Arielle is corroborated by her injuries. The physical evidence of Arielle's injuries corroborates exactly what she said. Think of the injuries to the top of her head. The stellate laceration. Dr. Grosjean told you there was debris throughout the entire injury. There were rocks. The defendant swung this rock so hard that pieces of rock broke off into Arielle's scalp. There was dirt throughout the entire laceration. And the middle of Arielle's scalp, he described as macerated or crushed. It went all the way down to the bone. You've seen the photo of Arielle from the front. You've seen what's missing from her head. You've seen that there is a chunk of her scalp that is gone. It's right there in that photo. And you've seen that she didn't just have scalp injuries. She had injuries above her eye. She had injuries below her eye. She had injuries to her hand, not even to just her thumb. Her thumb was only where there was a break, but she had injuries to 3 of her fingers, her thumb, her index, and her middle finger. Arielle's testimony is corroborated by the physical evidence in this case. Arielle's also corroborated by the digital forensics, the digital evidence. The digital evidence tells you what defendant was thinking, what he was thinking from December 2024 to March 2025. It shows you that, first of all, it confirms the motive. It confirms the strong motive defendant had to kill because he was looking up infidelity. He was looking up Arielle's financials. He was looking up his prior divorce. He was going into Arielle's hard drive to look up documents on her computer or from her computer about divorce. He even went to the point where he was buying a spy device to spy on Arielle. This shows what was going on in defendant's mind. It wasn't some simple research. It wasn't taxes. It wasn't self-help. It was obsession. It was an obsession with Arielle. It was an obsession with infidelity. It was an obsession with going over those financials, and it was a plan for divorce. The second thing that the digital forensics shows, most importantly, it shows defendant's familiarity with that hike. It shows you what the defendant looked at before deciding the Polypuka Trail is the hike that he should be taking Arielle on. It showed the defendant this picture right here. It showed that the defendant was only interested in difficult hikes. Easy hikes were not for him. The defendant wanted difficult hikes, steep trails, big drops, narrow trails. This is where the defendant wanted to take Arielle. This trail, about a foot wide, somewhere around there. One push is all it would take on this trail. Nothing for her to grab onto. One push, and it's a tragic accident. That is what the defendant was researching. He knew that this trail was not popular from his research. He knew that 99% of the people wouldn't be going on this trail. He knew that this is where he could execute his plan. And he didn't share this with Arielle. He didn't share this website with her, so she could make that informed decision before she went on that hike with him. She had no idea what kind of trail she was getting into that day. Lastly, Arielle is corroborated by the other witnesses. Arielle is corroborated by Amanda Morris. Amanda Morris, the first person on the scene. Amanda told you the sequence of events. 3 things. First, she heard a woman's voice screaming, "Help, help me." And she gets up the trail because she thinks somebody's fallen off. She knows it's dangerous, she thinks somebody's fallen. And she sees the defendant over Arielle. Amanda sees the defendant over Arielle. She sees the defendant with this rock in his hand, and she sees the defendant hit her. And when she sees that, Arielle cries, "Help, he's trying to kill me." And Amanda sees how the defendant responds. How the defendant responds is nothing. He just looks at her. Arielle's also corroborated by Sarah Buxbaum, the second woman on the scene, the second hiker who intervened. Sarah came in behind Amanda. She saw the defendant standing over Arielle. She saw the defendant standing with that rock. And most importantly, Sarah looked the defendant in the eye. Sarah made eye contact with the defendant and told you how that made her feel. It made her feel unsettled. It made her feel so afraid for herself and her safety when she was looking at the defendant in the eye. It made Sarah feel so unsafe that she and Amanda went back down the trail before they called 911 because they realized this was a dangerous situation for them. They realized, after looking in his eyes, what could happen to them. And they took those steps after seeing what was in the defendant's eyes. After seeing that look, they took steps to protect themselves. Listen to Sarah's voice on that 911 call. It's Exhibit 3. You'll have it. Listen to her voice and you can hear what she's thinking about. You can hear the worry in her voice. You can hear that she's afraid for her own safety after she's seen the defendant. It's all there. And you may hear argument today or have thought, maybe you thought to yourself, well, Amanda and Sarah only saw the end. The evidence shows that Amanda and Sarah didn't see the end of the incident. They caused the end of the incident. Because when they showed up, that is the only thing that stopped the defendant. Arielle screaming for help didn't stop the defendant. Arielle fighting back for her life didn't stop the defendant. The only thing that stopped the defendant, the only thing that was enough for him to stop, is 2 eyewitnesses coming up on the scene and seeing him beat her with that rock. The only thing that got him to stop was being caught red-handed. The responding officers, Corporal Wu, Corporal Chun, they corroborate Arielle as well. They showed you the hike. You saw the hike on their body cam. You saw their struggles with trying to get up the hike. They showed you the scene. Once more, right there in the foreground of this photo, that's where this happened. That's where the beating with the rock happened. And right there, just a couple feet away, that's where the defendant tried to push her. They showed you Arielle's condition. Arielle's condition immediately after the defendant did this. They showed you that. They showed you the closest thing to what the defendant last saw Arielle as. And they even caught it on their body cam. They even caught Arielle's condition as she states her name.
Arielle Konig. It's A-R-I-E-L-L-E. Birthday is March 24th, 1989.
You heard Arielle testify for hours, but also you heard in this video her slurred voice, her heavy breathing, her condition after the defendant beat her with that rock. She was not okay. The manhunt corroborates Arielle as well. It took 3 different agencies, HPD, DLNR's DoCare, HFD, several different units from them, SED, SSD, a canine unit, the major events unit to search with drones. It took 2 drones, 1 helicopter, and after 8 hours, or almost 8 hours, they were still not able to find the defendant. And that tells you one incredibly important thing. The defendant did not want to be found. The arrest corroborates Arielle just as much. Officers Nicola, Koki, and Borges approached Arielle in their vehicle. Officer Nicola testified he got within an arm's reach of of the defendant before he jumped out the car.
Objection. Misstates his testimony.
He got within an arm's length, or close to an arm's length, before he got out that car and tried to apprehend the defendant. He identified himself as police. And how did the defendant respond? The defendant tried to flee into the woods. It took a total of 835 pounds of HPD officers to subdue the defendant. That's how much he was resisting. He knew they were police. They identified themselves as police. And as Officer Nicola testified, the defendant, in his attempt to get away, fell on his face, and then Officer Nicola fell on top of him. That's why you see the grass on the defendant's head. That's why you see the dirt on the left side of the defendant's face, because that's where he hit the ground. That's where he hit the ground while he was being arrested. And the defendant's own actions, finally, also corroborate what Arielle told you. Defendant's actions corroborate Arielle's testimony. First, he fled the scene. Second, he collected the evidence from the scene. He collected Arielle's phone. He collected Arielle's purse. And he collected those syringes. He took all those items from the scene and he disposed of them. Arielle's mom still tried to ping her phone, and it was up at the poly hours later, but they could never find it. And think back, where Doe Care couldn't search. They couldn't search the bottom of the cliff. They couldn't get down that way. They searched the whole mountainside, couldn't find it. But the bottom of that cliff that's several hundred feet tall, that's where they couldn't search. Defendant confessed. Defendant called Emile just minutes after the incident and told Emile, "I tried to kill Arielle, but she got away." And lastly, the defendant hid in the woods for almost 8 hours. These actions that the defendant took corroborate what Arielle told you. They make sense. That being said, the defendant in this case has testified. And you need to judge his testimony the exact same way that you judge anybody's. At the beginning of this trial, you heard a theme, some alliteration with a theme, unwilling or unfaithful, unwilling, untrue. But ladies and gentlemen, after listening to the defendant's testimony, you only need one word to summarize it. One word. Unbelievable. The defendant's story. She started an argument. The defendant's story is that somehow Arielle, on her birthday, on an unfamiliar hike next to a massive cliff, decided to start an argument. Does that make sense to you? No. Arielle decided somehow to start an argument about she said she wanted to go back and continue to work with Jeff Miller. She wants to travel with Jeff Miller. Does that make sense that Arielle would bring this up on that cliffside? No. It contradicts common sense. It even contradicts the defendant's own testimony, where he told you they don't talk about this outside of counseling. The defendant told you that, and that's what worked for them. And somehow Arielle's bringing it up, ruining her birthday on a hike. Ladies and gentlemen, it's unbelievable. The next part, the defendant's story. She pushed me. The defendant says he felt a hard push from behind, that he was looking out over the cliff. He barely holds himself on. He turns around, and Arielle's already 5 to 10 feet away. Ladies and gentlemen, unbelievable. Arielle was trying to push him off that cliff. She wouldn't be that far away. She would have been right behind him, trying to push him again. Defendant's story. She pulled me down on top of her. Think about how that makes sense. Defendant's story is that then he approached Arielle. That he grabbed her arms. And Arielle somehow responded by pulling him down on top of her and not letting him go. Defendant's bigger than her. Defendant's stronger than her. Ask yourself, what person would hold a bigger, stronger person on top of them as an act of aggression? It doesn't make sense, it's unbelievable. Defendant's story, she hit me first. Somehow while Arielle's sitting down, or while Arielle's underneath him, while he's in the position of power, while he's on top of her, the story is that Arielle held him down so he couldn't escape, grabbed his genitals, wrapped her legs around him, and then she picks up a rock and hits him in the face. And as the defendant told you, he said, "She hit me one time really good," and that she keeps swinging. The same rock that defendant used to beat Arielle? Really? The same rock that defendant has told you he only used 2 times, that he only hit her twice with. Ladies and gentlemen, it's unbelievable. The same rock, no. You can tell it's different injuries. This is the photo of the defendant immediately after his arrest. This was the photo of the defendant almost 8 hours after the incident up on the trail, after the defendant tried to kill Arielle. Yes, there's a small dark spot on his cheek. Is it a bruise? Is it dirt? I don't know. This is Arielle. The idea that this same rock caused these different injuries is unbelievable, ladies and gentlemen. The idea that Arielle could hit him really good, and that's it, is unbelievable. This is the defendant at the hospital that night, and this is Arielle at the hospital on the same day. Again, minor bruise, major laceration. The idea that these injuries were caused by the same rock, completely unbelievable. You can only see that by looking at the next day. Look at the defendant 1 day later. There's nothing. There's no more. Arielle's got her head wrapped up. She's still got these injuries on her eye. The defendant's story is unbelievable. And lastly, the defendant told you that he wanted to turn himself in. That that's what he was doing when he left the trail. Sunset was coming soon. The sun was getting low. But instead of doing the logical thing and walking down the trail where he knew the police would be, the defendant decides he has to come out of the forest onto the road. The defendant doesn't go back to the trailhead. He doesn't put his SIM card back in his phone. He doesn't turn his phone on because he's not trying to surrender himself. He's not trying to turn himself in. He's trying to escape. And that's why he ran when the police apprehended him. That's why he resisted. The defendant's story, unbelievable. The defendant's story, unlike Arielle's, where Arielle is corroborated, the defendant's story is filled with contradictions. The defendant is contradicted by Amanda and Sarah. Somehow, Arielle finally let go of his private parts, and then he just stands there and looks. He's not on the ground writhing in pain? Does that make sense? He says that she held on so hard that he couldn't escape. Does it make sense that afterwards he would just stand there and stare? No. The defendant is contradicted by the physical evidence. He's contradicted by the fact that there's no blood of his up there. There's no evidence of injuries that support what defendant says happened. He's even contradicted by his own hired doctor. The defendant told you he hit her twice. No more. But even his own doctor said 2 to 3 hits to the scalp. Hits to the face. Hits to the fingers. So even the defendant's own witness shows that he hit her more than twice. He hit her, add them all up, 4, 5, 6, could be any of those times. He hit her again and again and again and again. And he only told you 2 times. Ladies and gentlemen, it's unbelievable. He told you he removed his SIM card with a paperclip. Well, State 72 through States 86, that's all the photos. That's all the contents of defendant's backpack. Where is that paperclip? He could have just as easily used that syringe. Open his SIM card, dispose of the syringe. Hiding evidence 2 ways at once. The substantial step again. He made the plan. He made the plan to go hiking that day. He didn't share with Arielle what hike they were going on. He didn't share the details of that hike with Arielle. He didn't share the dangers of that hike with Arielle because his plan was to push her off that cliff. So they start the hike, and Arielle deviates from the plan. Arielle doesn't go up to that section from the photo, the super narrow section with no trees. Arielle doesn't want to go up there. So the defendant improvises. The defendant takes a different cliff. The defendant sees his last chance when they take this selfie, his last chance before they get to that lower part of the trail. And he takes it. He takes that chance to try and push Arielle off. He takes that chance. He makes that substantial step. And plan A, the push, doesn't work. Arielle falls to the ground. He can't push her off anymore. So he takes that next step. He pulls out the syringe. Plan B. He tries to stab her with it. Plan C, when that doesn't work, he takes that rock and he hits her well over 2 times. He hits her again. He hits her again. It doesn't matter that she's blocking. It doesn't matter that she's screaming. The only thing that gets him to stop is these 2 women who walk up. That's it. You have gotten instructions about self-defense. It should be clear, the defendant was using deadly force in this case. This rock is known to the defendant to cause death or serious bodily injury. You don't need to be a doctor, although he is. And he's actually treated patients who've had rocks fall on them. So the defendant is well aware of the damage that he was doing. He's more than aware because it was his intent. It was his intent to cause that damage. It was his intent to cause death. So yes, it is clear the defendant was using deadly force. And because of that, self-defense doesn't apply. Or self-defense does apply, but defendant cannot claim it because he was the initial aggressor. He was the one who started the physical altercation. He was the one who used deadly force. And lastly, he had a duty to retreat. When using deadly force, before you use that deadly force, the law states you have a duty to retreat. And the defendant didn't do that.
Incomplete statement on the law.
Objection overruled. Ladies and gentlemen, the court instructed you on what the applicable law is. You need to follow the court's instructions as read out to you and as it's provided in the jury instructions that you have.
The defendant did not follow the law. The defendant attacked her. Self-defense is not applicable. The state has disproven it beyond reasonable doubt because the defendant was the initial aggressor. The defendant was the first one to use force. Based on these facts, self-defense is not applicable. Next, you're given instruction on extreme mental or emotional disturbance. This is a long instruction. We'll keep it simple. There's no evidence that the defendant was acting under extreme mental or emotional disturbance when he tried to kill Arielle. Don't be confused by his testimony. He did say he was under severe emotional distress, but he said that after he tried to kill Arielle. He said he was under severe emotional distress after he started to think about how this would affect his job, how this would affect his life. He was under severe emotional distress after he began to think about the consequences of his actions and how his actions would affect himself. That's what that is. The defendant was not under extreme mental or emotional disturbance when he tried to kill her. He only became that way when he began to think about the consequences. The second part of that instruction states that the defendant's self-control, the defendant's logical thinking is important here. It shows the defendant, when plan A didn't work, he moved to plan B. When plan B didn't work, he moved to plan C. And when he got caught, he fled the scene, he hid the evidence, and he hid himself. That shows the defendant was using logical thinking. The defendant was solving problems as they came. He was not acting under extreme mental or emotional disturbance. Okay. You got a list of other included offenses. You got a list of a bunch of assault charges that are included in the attempted murder and second-degree charge. When you think about those, just think one thing. He did more. This is what he did. Assault in the third degree, causing bodily injury. Ladies and gentlemen, that means physical pain. He did more. He did more than cause physical pain to Arielle. Assault in the second degree. He did more. Yes, the defendant caused a major laceration to Arielle's head, or severe laceration. The defendant caused a bone fracture to Arielle's thumb. Yes, he did those things, but he did more. But he did more because he was trying to kill her. Attempted assault in the first degree, same thing. Defendant took actions that he knew would cause a substantial risk of death. Yes, but he did more. Because the evidence all shows that the defendant wasn't intending to do an assault. The defendant was intending to kill. All right. 3 things: motive, a beating, and a confession. You've seen through this trial the defendant's motive. He was upset. He was angry. Wherever he turned, Arielle wasn't being punished. First, he talks to Arielle's best friend, tries to air the dirty laundry. But the best friend stays on Arielle's side. Deanna stays on Arielle's side. She's not punished. Then he emails Andrea Miller. Giving this other woman Arielle's personal contact information, her cell number, her personal email. But Andrea Miller never responds. Arielle's not punished. And then he goes to counseling. They go to marriage counseling. And instead of focusing on the affair, what do they focus on? These intimacy issues, these issues that Arielle testified about, these issues that were defendant's fault. Everything the defendant tried to do made sure Arielle was never punished. So he did it himself. Every response defendant had to this emotional affair showed the defendant's need to control Arielle. He wanted to control where she lived. He wanted to separate this woman from her 18-month-old child. That was his response. His response to finding out was, you should move out. He wanted to control her job. He wanted her to quit. He wanted her to be dependent on him. Because once Arielle quit her job, it's much harder to divorce. She has no more income. She can't go find another remote worker, nuclear engineer job. The defendant knew how much a divorce would cost. He was looking at his own documents, his own records from his prior divorce. He was looking at his own records that showed how much he paid in his prior divorce, because that's what he was thinking about. He was doing that math. He was doing that math on what it would cost to divorce Arielle, what he would give up. And he just couldn't stop thinking about it. He couldn't stop thinking about this emotional affair that he's built up in his head. And because he couldn't stop thinking about it, he made a plan. He made his plan to kill Arielle. The beating. Plan C, the third substantial step, the one that's the most visible, the one where she got these injuries. The defendant took the rock. He picked it up. He swung at Arielle again and again and again and again and again. That many swings shows that the intent was not just to hurt. It was not just to defend. The intent was to end her life. That's what the number of swings tells you in this case. Arielle's only relief, the only thing that stopped him, was the defendant being caught in the act. It was the intervention of Amanda Morris and Sarah Bucksbaum. That's it. So we end with the confession. 10:42 a.m., just a couple minutes after this happened, the defendant calls Emile. It's a video call, not a phone call. So Emile could see what the defendant was saying. He could see the defendant's face. He could see the defendant's mouth moving. There's no gray area with this confession. As Emile testified, he has no doubt about what the defendant told him. There's no phantom gust of wind that came up. There's nothing like that. The defendant confessed to Emile. He told Emile that he tried to kill Arielle. He told Emile why. He told Emile that Arielle got away. He told Emile that Arielle was having an affair. That doesn't sound like a goodbye suicide message, does it? He told Emile He was at the end of this rope. And think back to the last thing that the defendant told Arielle before he tried to kill her. He told Arielle, "I'm sick of this shit." That's corroborated that he's at the end of his rope. Same idea. What didn't he tell What didn't the defendant tell Emile? Nothing about self-defense. Nothing about Arielle attacking him. Nothing about what he testified to you. Is that reasonable? Does that make sense? No. 10:42 a.m., the defendant FaceTime video calls Emile. He confesses. And Emile's next step, after being put in that situation, as a 19-year-old that he had no want to be part of, Emile does what he does. He goes and tells his grandparents. He goes and tells them what the defendant said. And Judith Mast, ends up texting the defendant, 11:33. She texts the defendant, "Is Ari okay?" She asks the defendant about her daughter, and the defendant says nothing. He doesn't respond. But what he does do shows his intent. What he does do, he calls Emile again, and he asks him, "Did you tell anybody?" That shows the guilty conscience of the defendant. That shows that the defendant was not acting in self-defense. That shows the defendant was thinking about what his actions would do to himself. He was thinking about himself. He wasn't thinking about Arielle. He wasn't thinking about her condition. It was only himself. So, ladies and gentlemen, there's one verdict and only one verdict that does these things. There's one verdict that holds the defendant accountable for what he intended to do, for what he tried to do to Arielle. There's one verdict that's supported by the physical evidence, the digital evidence, the corroborated testimony of witnesses, and the defendant's own confession. There's only one verdict that's corroborated that makes sense with all of that. There's only one verdict that the evidence and justice demands. And that verdict is that you find the defendant guilty as charged of attempted murder in the second degree. Thank you.